Hi, everyone. Jesus says in John chapter 10, verse 10, I am come that they may have life and that they may have it more abundantly. Welcome to another episode of the Life More Abundantly show, where we share personal testimonies and cover various topics designed to point the viewer to the more abundant life found in Jesus Christ. Before we go into our topic for tonight, I just want to make the following announcement. Yours truly is available for singing and speaking in-person worship services in the state of Alabama and virtual services worldwide. You can inbox me at Marcina Cook Ministries Facebook page or email me at marcina_cook@yahoo.com for more information. In this day and age, it is important to not only prepare for the life to come as Christians, but to also have our affairs in order for the sake of our families. As uncomfortable as the subject may be, the Bible tells us that death is a reality that we must all face sooner or later. Hebrews chapter 9, verse 27 says, "It is appointed unto men once to die." Planning our wills and estates will help make it somewhat easier for our families and loved ones to take care of our affairs after we pass away. It also protects them so they can legally receive their inheritance. Proverbs chapter 13, verse 22 says that a righteous man leaves an inheritance for his children and his children's children. So tonight we're going to talk about the importance of planning wills and estates. And our special guest will be Mr. Rodney Davis, Esquire. Mr. Davis is an attorney in Birmingham, Alabama, who is the head of the law office of Rodney Davis. His areas of practice include estate planning, real estate, and personal injury. A native of Hillsborough, Alabama, Mr. Davis graduated from the University of Alabama at Birmingham, where he received a Bachelor of Arts in Communication Studies. He then graduated from Thomas Good Jones School of Law, where he served as communicator of the Christian Legal Society, senior editor of the Faulkner Law Review, and member of various other organizations, including the Faulkner Law Board of Advocates. Mr. Davis is admitted to practice in all Alabama state courts and the United States District Court for the Middle District of Alabama. Outside of work, he enjoys spending time with his wife and daughter, fishing, and golfing. Ladies and gentlemen, it is my honor and privilege to present to you Mr. Rodney Davis, Esquire.
Good evening.
Yes, good evening to you, sir. How are you?
I am good. Thank you so much for having me on. How are you?
I'm doing fine, and I'm very honored for you to be able to share your expertise on this topic tonight.
Absolutely. I'm excited as well.
Yes, indeed. First question is, does everyone need to have a will, or does one have to be wealthy in order to have a will?
Yes. Absolutely. Everybody needs to have a will. Having a last will and testament, or having an estate plan at all, for that matter, has really nothing to do. It's not just about how much you have in assets or how wealthy you are. Everybody needs to have not only a will, but an estate plan in general, for various reasons outside of how much wealth you have or how much assets you have. So absolutely everyone should have a last will and testament.
Certainly. What is the legal importance of having a will and planning one's estate?
Well, the legal importance is understanding that, absent an estate plan, the state law in whatever state you live in will determine what happens with your assets. If you pass away without an estate plan, the law will determine what will happen if you have minor children, who their caretaker may be, how they will receive assets that you leave to them. And so the legal importance of having an estate plan or having a will is that you get to make those decisions yourself, because you know what's best, you know what your wishes are, and you get to make those decisions yourself by having a will or by having an estate plan in place. Whereas not having it is you basically giving up that decision to the state in which you live in.
I think we should clarify, in the case of minor children, that would be if both parents pass away and have not designated someone to care for them.
In most cases, but I mean, you could also, take into consideration, even if both parents haven't passed away, if for whatever reason one parent is unfit and that has been determined before the other parent has passed.
I see.
If the fit parent passes, then in most cases, the children won't automatically go to the remaining parent, especially in situations where that other parent has been determined to be unfit.
Right.
And so it's not necessarily automatic that children will go to that surviving parent if one of the other parents passes away.
Okay. So I guess I just wanted to clarify that, because I'm sure that most of us, we would be able to take care of our own children if our spouse should pass away. But I guess you're saying there are other circumstances where if both of them are fit, that is.
Yes. Now, if both parents are fit, then yes. If one parent passes away, then the children will automatically most of the time be taken care of by the surviving parent.
Of course.
But there are other circumstances where that may not be the case. And another situation would be, well, what if one parent is incarcerated and then then the other parent passes away?
Okay.
And so, yeah.
Yeah, we just don't want people freaking out like, wait a minute.
No, don't freak out. If as long as you're, available, you're fit, then there's no other reason why you shouldn't be able to take care of your kids if your spouse or
Absolutely. But that is something to consider when planning one's wills. You want to make sure that is taken care of. In the case of your minor children, you want to be sure of that situation to be handled. So what are the most important elements in a will?
Well, in a will, wills can be pretty simple or they can be pretty complex. At a really basic level, some of the elements in a will include, number one, choosing who you would want your executor to be in your will. Now, your executor, is the person who they don't necessarily receive everything that you own, but they are the person who is responsible for making sure that number one, if you have any debts that you had unpaid before you passed away, that those debts are paid and they're paid out of your estate. And after those debts have been paid, the executor is in charge of making sure that your assets go to the individuals, the beneficiary that you've chosen in your will. Okay, so that's one element, choosing your executor. Now, if you have minor children, you'll also want to designate what's called a guardian for your children. You'll need someone to make sure that whatever you leave to your children, that those assets get to your children, and they get to your children when they're supposed to get to your children. Yes. And so those are a couple of important elements. And of course, in your will, you're going to decide, who gets what out of your estate. What assets are you leaving, and to whom are you leaving those assets to?
Certainly, that is very important. Now, what are the most important elements in planning an estate? Is there a difference or are there similarities?
Absolutely. So I like to break. I would like to break that answer down into two. I think two main elements and then a few sub elements. So when it comes to estate planning, most people think that you're basically just planning for what will happen when you pass away, and that's certainly part of it. I like to think of that as end of life planning, but you also have lifetime planning as well. And so, starting with end of life planning, you have of course, your last will and testament, which determines, what will happen with your assets if you pass away. You have trusts, which do the same. You also have, disposition authorizations for what happens with your remains and who plans your funeral and things like that. But you also have lifetime planning as well, which will determine what happens, not necessarily when you pass away, but if you're alive and maybe you can't speak for yourself. So you have a document such as advanced directives for healthcare, which will allow you to designate the type of treatment you would want in certain situations. If, let's say, you're in the hospital and you're incapacitated and you can't speak for yourself. So you have a document here that will speak to the type of treatment you would want in certain circumstances. Another part of that is appointing someone called a healthcare proxy who can speak on your behalf to a physician or a healthcare provider if you're not able to speak on your own behalf. And so you also have documents such as powers of attorneys, documents where you can give someone the authority to speak on your behalf to make certain business and financial decisions for you in the event you're not able to speak on your behalf or make those decisions yourself. And so you have both lifetime and end of life planning when it comes to estate planning. And both of those are really just as important, I think, as the other.
Yes, certainly that is very, very informative. How does one go about the process of getting a will together, and how can it be made legally binding?
Well, when it comes to going about getting the last will and testament or any other estate plan document, I think the first thing you need to do is contact an attorney. Don't rely too much on these DIY services that allow you to create and draft documents on your own. And one of the reasons why is because a lot of these documents have legal, what we call legalese, which is just another word for legal terms and legal language that you may not understand, and you may need an attorney to explain those terms to you. And so I think the first thing is to definitely contact an attorney, schedule an appointment, tell them what your goals and concerns are when it comes to your estate. Some of the things that you want to make sure in place if something ever happens to you. And so definitely contact an attorney. When it comes to a will, and this is one of the reasons why you definitely want to contact an attorney, because wills, for the most part, the requirements are that you have what's called legal capacity. That's one of the first requirements. And by legal capacity, what is meant is that, number one, you're of the right age. You have to be at least 19 years of age in Alabama to execute a will. You also have to have the right mental capacity. You have to be of sound mind, free of any type of duress or pressure when creating this will. You have to be able to understand, what this will is, what the legal consequences are of drafting this will. Another requirement is that at a minimum, your will has to be witnessed by two individuals who also have sound mind, who are also at least 19 years of age. And so your will needs to be witnessed by at least two individuals. And this is not technically a requirement, but it's definitely good to do. Is having that will notarized. And that's another thing that if you don't contact an attorney, you're probably not going to know or realize those things. And so I would say definitely contact an attorney to get started on having any documents in an estate plan drafted.
Okay, now here's the question, because some people are thinking, okay, how am I going to be able to afford an attorney to get this
Mhm.
done?
Mhm.
Which is probably what makes the online option so tempting. So what are the affordable ways that people can at least start to get it done, and how do we go about that?
Well, I think that, when it comes to, fees and attorney fees and an estate planning, I think a lot of people will assume, that it's going to be a lot more expensive. And in some case, maybe it will be. I think in a lot of cases, it's actually not more expensive. As a matter of fact, you may find that depending on the attorney, it may even be less expensive. But I think one of the main reasons to have an attorney, regardless of the cost, is that you have someone here who you can speak with, specifically about some of the concerns you want, that you want to have addressed in your will and in your estate documents, that you may not be able to have with DIY services. And so I think regardless of the cost, and again, I think many people would be surprised at the cost when it comes to having an estate planning attorney prepare documents for you. I think regardless of that, it's definitely good to have an attorney involved to make sure that you have a good understanding of your estate plan and what these documents mean, and the importance and impact of these documents.
Well, I guess we'll just have to, prayerfully seek the right counsel. Certainly, it's better to plan well
Yeah,
than plan in a haphazard fashion.
yeah,
And I'm sure that the fees, if people do the research in their own state for those services, I'm sure there won't be, as momentous as we probably think it might be. It depends,
yeah,
but I guess I'm thinking of people who um, don't have millions of dollars, and
yeah,
people who have, you know, fixed income and those
yeah.
type of situations.
Well, you would really, like I said, you'd be surprised. I mean, many counties and states have services that can provide these documents free of charge. Uh,
Hmm.
as a matter of fact, I myself, I've even volunteered and participated in clinics where we provided documents to individuals and families free of charge. Many times churches will have seminars, and attorneys will provide at least free wills for clients, and so there are a lot of resources out there for individuals who want to do estate planning, and there are many services out there that will provide services to clients, regardless of what your social economic status is or what your income is. I know here in Jefferson County alone, we have a place called Legal Services of Alabama that provides these types of services. You can contact the Birmingham Bar Association, which has a volunteer lawyer section that provides these type of services. So there are all kinds of resources out there, to assist clients who may not necessarily have the means to be able to afford traditional fees charged by clients. I think if you are someone who is concerned about that, you could contact, the state bar for the state that you live in. You could contact a local bar association, and you'll be amazed at how many resources are out there.
That's wonderful. I do appreciate that, because there are some, as we talked about earlier, there is the concern of you having to be at a certain level of wealth to plan a will. And since it is so important, not just for monetary reasons, but also for other things like um, designating guardianship of your children and so forth, you do want to make sure you have competent legal counsel. And I'm grateful that we can contact the state bar of whatever state we're in and hopefully get in the process of getting those resources. Because we
Absolutely.
want to do everything decent and in order.
Absolutely.
Um,
Absolutely.
so as tempting as it might be to go online, I think we'll try to go about it the right way.
Absolutely. Absolutely.
Yes, indeed. Now, okay, number 6, is a will or estate planning always about money and or possessions, or can other important items be included in? I know we talked about guardianship of our children. What other issues can be considered?
Well, I think one thing that is not talked about nearly as much as it should be um, is a thing called legacy planning. And that involves, um, kind of touching on, what your values and your beliefs are as a person, not necessarily dealing with assets, especially tangible assets, but really dealing with some intangible assets such as your values and beliefs. You can certainly draft what's called an ethical will, which is, I like to think of it as somewhat of a love letter that you're writing to your loved ones. That's really expressing to them some important values and reflections that you would like to leave your family with. And so, I guess to answer your question, you don't have to necessarily only deal with leaving assets and property behind. You can also deal with leaving behind beliefs and values as well. When it comes to having a last will and testament, you certainly touched on appointing a guardian for minor children. Another thing that you can do is you can also appoint someone to manage assets that you leave to someone who's maybe disabled. You may have a family member who is not necessarily a minor, but they are disabled, and so they're not really capable of being able to manage and take care of the assets or things that you've left to them. And so you can put someone in place who's responsible, who's I would think is a pretty well-rounded person, someone who's not going to take advantage of what's left to an individual who's disabled, and they can be someone who will manage and handle items and assets that you leave behind to someone who is disabled. And the importance of that is that generally when you have someone who's disabled, they may very well be someone who's receiving maybe government benefits, and you have to really be careful with a situation like that, because you don't want to leave assets to them in a way that may disqualify them for those benefits. But at the same time, you still want for them to benefit from what you leave to them. And so you can set up what's called a special needs trust, and have a trustee in place for that special needs trust to manage and handle what you've left to that individual.
That's very interesting, because I remember looking on your website and I saw that your law firm does deal with that. And as a parent, my husband and I are parents of a special needs teenager, and that's certainly something that we want to consider so that we can make sure that their other benefits are not jeopardized because of that.
Very important.
Yes.
Very important.
So let's talk about a scenario that I think might might be important to discuss. Let's say that the person is single
Mhm.
and they don't have children and so forth. And how what are some of the challenges that they may need to consider when planning a will or planning an estate? Are there any special considerations?
Well, I think in general, people have to overcome. I think a lot of myths, when it comes to estate planning, and I think one of those myths is that if I pass away and I don't have kids, then what is the of having a will or having an estate plan? And I think, you have to, consider that, well, while you may not have kids, do you have a spouse or do you have siblings? Do you have, parents who are still alive? Or also, do you have any causes that you're passionate about? And so I think, without having kids, there's still so many more reasons, to create a will and to have an estate plan in place. I think, the same things that apply, well, many of the same things that apply with having kids, I think some of those same important reasons still apply even without kids.
It's interesting what I have seen in some cases, some high profile cases where certain celebrities have passed away. And
Right.
there's been some very interesting surprises that we have seen when certain people do not have a will. And it can be very devastating to the families to not have those affairs in order. And so
Yeah.
um, it's something that really drives home for me the importance of doing that, the importance of checking what's available in your state, what's legal in your state.
Yeah.
For example, there are some cases where the spouse may not necessarily automatically get the assets.
Yeah.
We talk about that.
Yeah, well, and I've seen this a lot. That's the case a lot when you have mixed families. For example, you may be married to someone, but um, you may have been married before, and you may have children from a prior relationship or a prior marriage. And so it's important to understand, especially in those situations, that if you don't have a will in place, that can dramatically affect, how your assets may be disposed of if you pass away. Many people don't realize that when they're in that situation, they assume a lot of times that their spouse may get everything, but technically, um, your spouse won't get everything. Your spouse may get some things, but your children also will be accounted for as well. And so, without having documentation that clearly expresses how you would wish for your assets to be disposed of, not having that could have some pretty drastic effects for your surviving spouse, for your children, or really for both. And so I think that's a situation alone there where your spouse may not necessarily receive everything that you leave behind.
So this is why it's absolutely important to know what are the laws in your state and to just have the will, just have the will
Absolutely.
so that your spouse can be able, or your children, or whoever you leave your property to, they will be able to have a document that says, "Hey, this is what this person left to me."
Yeah.
Really.
Yeah, absolutely. I mean, I like I said, I deal with clients who are in that situation
Mm.
pretty frequently, pretty routinely, where they're again, it's a mixed family.
Yes.
One spouse passes away. They just assume that they're going to receive the house. The house was not in both spouses' name. The house was only in one of the spouses' name. For whatever reason, the surviving spouse and her stepchildren don't get along. And so, in that case, the house would technically go to both the surviving spouse and the stepchildren. But how do you handle a situation like that, especially when you're at odds with your stepchildren? How do you deal with a situation like that? And so it's just really important to get ahead of things on that,
Yes.
and make sure that you've put proper provisions in place for a situation like that.
Let's talk about, because sometimes some people are concerned, well, if I have the conversation, are people going to try to, take me out of here early and take my money? But I see it that it's so important for us to have those conversations, as difficult as they may be, so that our loved ones are not in the dark in
Yeah.
regards to who's going to get what and so forth. Because I think that it's so much better to have that stuff planned as much as possible, so that you can hopefully cut down on some of the fighting that goes on at funerals and all of that. We want to focus on remembering our loved one. We don't want to focus on these other things. So
Yeah, I mean, having that conversation, having those tough conversations is absolutely necessary. I would advise anyone who is considering estate planning to definitely have a conversation with your family members, with your loved ones. But understand that having a conversation is only the start to actually creating a plan. Yes, it's good to have a conversation, so that at least you have verbally and affirmatively made your wishes and your desires made known. But I can't tell you how many times I've met with clients who said that they believe they were entitled to something simply based on a conversation that they may have had with a loved one, with there being nothing further in place, there being no will in place, no documentation in place. All they know is that they've had a conversation with their loved one, and they remember that loved one told them that they were supposed to get the watch that he was leaving behind, not his sister. But at that point, what can you really do? No one is going to be able to simply rely on, you may have been told while this person was alive. That's just not going to be enough. And so, yes, having that conversation is definitely important. As a matter of fact, I think is almost necessary to have. But understanding also that you need to take it a step further after that conversation and actually put something in writing as well.
Yes. And granted, you may not be able to discuss that with everybody in the family. I don't think we're saying that, but at least have somebody designated who can be able to help you put in writing what your wishes are.
Right.
You can't talk to everybody, because that's going to be a long conversation that may never end. But at least talk to someone, and as you said, have it in writing, so that the person you talk to say, well, this is what's in writing.
And I think especially whoever your executor will be in your will, I think if there's anybody who you need to have a conversation with, it would be that person. It would be the person who's actually going to be in charge of managing in disposing of your assets if you were to pass away. They need to be able to not only have something in writing, but they need to hear from you. And I think one of the reasons why is because, believe it or not, there are some people, there are a lot of people who don't want that responsibility, you know. And so I think it's important to have that conversation, to at least make sure that whoever you're leaving as the executor is someone who not only can do the job, but someone who would actually be okay with doing it. Because you'd be surprised at, how many people they just don't want to be bothered with that type of job, because it is a lot of work and a lot of time that has to go into handling someone's estate. And you want to make sure that not only are you selecting someone who you've made your wishes known to, who has the capability and wherewithal, but someone who is going to be willing to do that.
Certainly. There's been a very good question that was posted in the comment section. Wills working documents that can be changed as needed? And that, by the way, was asked by my husband.
I see. Okay. Yeah, that's a really good question. And absolutely, they can be changed as needed. I have, out of all of the wills I've done, I've done a number of what's called codicils to wills, and that's just a fancy word for an amendment or a change or an update to a will. And so, absolutely, wills can be updated and changed. As a matter of fact, I recommend that even if you have a will drafted, that you at least have your will or your estate plan documents reviewed every 3 to 5 years. And the reason being is because there's a lot that can happen in that window of time. For example, you could get a divorce and remarry. You may have more children. You may simply just change your mind about who you want to leave assets to. And so I think it's definitely important to keep in mind that, yes, having a will drafted is a good step in the right direction, but it's not a one and done type of thing. There are many situations or circumstances that you may be in where it may be appropriate to have your will updated.
Well, we certainly appreciate that. This has been a very much needed beginning of a conversation that each of us need to have with our loved ones
Yeah.
and able to start the process of planning. And I absolutely appreciate you coming and sharing some of these things with us. Let's see. I'm not sure what else to ask, but I think we pretty much covered what we need
Okay.
to cover. And I certainly appreciate the time you have taken.
Absolutely. It's my pleasure. I definitely enjoy talking about this. I love, educating people on this. And so anytime feel the need to discuss this, I mean, we can definitely do it. There's a variety of topics that can be discussed and covered, under the estate planning umbrella. And
Mhm.
so I'm always willing to speak and educate, as many people as possible.
I just thought of something to ask. Um, as Christians, how can planning these things in advance help from a Christian perspective? How can that help us in dealing with the loss of a loved one, or help our families deal with the loss of loved ones in a more Christ-like manner? Hopefully, avoiding these sometimes very bitter and nasty conflicts that can happen after one passes away.
Well, I think from a Christian standpoint, um, is important to understand, that one of the good things about planning your estate is that you cut down on so much confusion that would otherwise lead to a lot of disagreements and bickering amongst your family members and loved ones. And so I think, taking that into consideration um, is the incentive that I think anybody, um, would need, Christian or not, um, is making sure that you're creating a situation where there isn't so much, questioning and guesswork that has to be done by family members, and so that there isn't so much assuming and arguing and having back and forth with family members about the type of things that you would have wanted. If you go ahead and put something in place, you sort of eliminate a lot of that happening. And so I think you're putting your family in a position to where they can focus more on grieving and
Yes.
being able to yeah, I guess, like I said, grieve and be able to, deal with your death on a more of an emotional level, versus, having to, make the experience 10 times worse by
Yes.
not only having to grieve, but having to also, deal with, who gets what and whatnot. You've already, made those plans, known to your loved ones. And so they're in a situation to where they've got it from you directly, and all that they have to do is make sure that that plan is followed. And in the meantime, they can grieve.
Absolutely. I was just thinking about how much less of a weight it is on the shoulders of loved ones when they can focus on remembering their loved one. They can focus on the grieving process and not have it weighed down with all of these extra burdens. And
Absolutely.
certainly we want to be able to do that so that our families can be able to go through that process with a little less stress.
Yeah, yeah, absolutely. And you mentioned a very important verse earlier. A good man leaves an inheritance to his children's children, and I think that that is something that is not automatic. I think that that is something that is done with intention, and that's something that's done carefully and by planning, and not just by assuming that it'll happen. There are ways that you can make sure that when you leave an inheritance, that you're not only leaving one for your children, but also you're taking steps to put plans and provisions in place for your grandchildren as well.
Absolutely. And of course, we did talk about, for those of our single friends, there are other people and other causes to consider that you may want to
Absolutely.
leave things, also leave a legacy that will be a blessing to other people, and to make it as official as possible.
Yes. Yes.
We have come to the end of our broadcast. Just want to once again share this link. And I'm sure that if anyone has any further questions, they can contact you. Of course,
Yes.
you are outside of the state of Alabama. You might want to use this interview as a springboard for you to contact your state and contact and find ways that you can be able to afford getting your affairs in order, getting that will together, getting that estate put together, because we're living in a day and time where we just don't know when death will come knocking at our door or our family member's door. And we want to be able to, as much as possible, have certain things in order. Thank you so much, sir, for coming. And,
Thank you.
and let's close with a word of prayer. Heavenly Father, we know that death is not an easy thing to deal with, and it's not a pleasant thing to talk about, but we also are assured by your promise that if we make our calling and election sure and make things right with you, we have no need to fear. And also, Lord, you have put people in place in our lives and in our society that can be able to help us get our affairs in order. We pray, Lord, that you will please give each of us the wisdom, put us in touch with the right attorneys, the right people who can give us the legal advice that is applicable in the state or country that we live in. And we ask, Lord, that you will help us to be able to plan our affairs in order so that when or if we should have to pass away, that we will be able to not only make things right with you spiritually, but set our families straight naturally. We thank you for hearing and answering our prayers in Jesus' name. Amen.
Amen.
And I leave you with the words of John chapter 10, verse 10. I am come that they may have life and that they may have it more abundantly. God bless you and keep you is our prayer.